Here we have Joy Bonaguro, an advisor and writer on data science and responsible AI. She's the former Chief Data Officer of California in San Francisco. In the middle, we have Dave Evans, who's the Chief Design Officer at OSOM Privacy, the company I work for. Previously, he held roles at Apple, Samsung, Playground, and was a lecturer at Stanford University. And on the right, Mary Stone Ross is the co-author of the California Consumer Privacy Act. Previously, she was counsel for the U.S. House Intelligence Committee and a CIA analyst. Someone in one of the previous sections had joked that policymakers and executives, are kind of disconnected from the engineers, you guys, when it comes to making privacy implementations and vice versa. And I hope that we can form the exception that proves the rule here. Just avoid any math questions if you can. So to start, I think we were going to summarize some of the recent changes that have happened in the privacy landscape as they apply towards the sort of engineering decisions that you guys make and the analytics that you collect. So let's start with you, Joy. Can you tell us a little bit about some of the tools that you guys use in the private sector and some of the prepared remarks that you had there?
Yeah, I mean, maybe I'll start with, so since we're talking about the privacy boogeyman, right, in this session and about how to actually operationalize and use data, I'm going to come from the sort of public sector perspective and how we've done this, because we've been a lot more regulated than you all for a long time in the private sector. So, so I'll start with maybe an example where we had to use private sector data and how we had to approach that. So does anyone remember what happened on March 19th, 2020? Do you remember 2020? I sure do. I had just started my role as Chief Data Officer of California, and on March 19th, we issued the lockdown order to shut down California because of that little pesky thing called COVID. Y'all might remember. And immediately this begged a question: how the hell were we going to monitor the state of lockdown in the state of California? And who has the best data on movement in California?
Google.
Who else? Who else? Government? You think government has the best data on that? Wow, which government, I'd say, first of all. There's different levels. And then second of all, yeah, government. We had highway data, right? We had really robust highway monitoring data, so we could track that. We certainly can't track local routes or anything. We don't have that kind of information. But obviously your Google, I don't have it with me. That phone thing, right? That phone thing tracks so much, right? And so we had these companies that were like, hey, some of the companies wanted to give us the data. And as the newly appointed Chief Data Officer, I was like, no, I don't want that data. You don't want to give us that data. That's a terrible idea. Some of the companies were like, wait, yeah, we're not giving you that data. But when we were able to negotiate, and I want to thank the companies that provided this, it was Google, it was Apple, Yelp, all of these companies ended up putting out essentially data sets that allowed us to track movement across every city, county, and jurisdiction in California. And all of that data made it into the daily briefing book that went straight to the governor's office, and it said, here's who's moving around in California. Here's who's not moving around in California. So I just offer that as an example to kick off this panel that we didn't ever have to touch that data. We ended up using these, sort of these data products instead that these companies very generously made available, and it was able to inform major policy decisions. So one, we were able to, confront the privacy boogeyman, and then two, we were able to actually focus on what data do we actually need to answer the question. And I think that always has to drive from the public sector. So I'll stop talking from that angle right now.
So the next bit of prepared remarks we had here were with Dave and Mary. So the company that the three of us worked for designed some consumer-centric privacy solutions. And the implementing privacy by design in different circumstances, as you guys know as engineers, can be difficult. And we have some context in terms of what it's like doing privacy by design from end to end, from the executive level to the product level, engineering, marketing. I want to make sure you guys have an opportunity before we dive in any further to discuss what it's like handling user data in a privacy protective manner with privacy by design at all levels.
Sure, I'll back up one step. So I think in terms of like the title, like the privacy boogeyman. So I am like a hardware startup guy. I've been in a lot of different consumer electronic startups, getting them going. And I joined OSOM when the fundamental theory was the team, quite small, had made a lot of cell phones, mostly Android platform. And we're like, we need to carve out a new niche we could get going for. So like what would be actually marketable, both to consumers and also to venture capitalists, because the reality is that's who pays our bills up front. And so we're like, hey, privacy is a huge deal. Like all this, data loss, we're paying for our products with our privacy, with our data, with our information. That's what's actually the product. How could we invert that? Could we go out and make a consumer-grade pitch about making a cell phone that works for the person and on their terms, and stripping out any possibility of the business model being driven by data and analytics? Setting aside the value judgment of that, just like, could we even make that a business case? Spoiler alert, not really. So but we can get into that in great detail. So we've been at that for a better part of 4 years. It's going poorly, right, is the reality of the thing. Some of that's about the hardware market just being entirely commoditized and not being able to punch through the noise. And some of that's about the difficulty in marketing that as a pitch to actual people. And that being said, we said don't ask us math questions. So my background, again, is on the hardware side and the design side, but I helped kind of steer a lot of the strategy and the marketing pitch for what we're going to be doing and how we've brought that narrative into what we actually build day to day and the choices you make when you start from a team of like 5 people all the way through staffing up to tackle larger problems, and how you keep that kind of first principles thinking going and making sure that all of it kind of lines up more authentically.
I like math.
And I, of course, came from the public policy space. So it was interesting for me to go work with a team of engineers to try to bring a product to fruition that, I hate the term privacy by design because I think it gets thrown around a lot and people don't really know what it means, or if they do, they're not actually doing it. But I think that the team that we built at OSOM and the engineering team, we in fact were doing it. We were thinking through what we built a smartphone and some other products too, but what a privacy-focused device should look like, both from a hardware perspective. So for example, we have a cable that goes with the phone to charge it. Another term that's been thrown around a lot is juice jacking. So you plug into a public charger, and instead of just charging your phone, someone on the other side is taking information from it. Or, I think the better example is you're riding in a ride share, you want to charge your phone, but you don't want all your data going to the car and whoever else. So our little cable, actually, Dave can describe it better.
You can just turn off the data lines. We just put a physical switch on it, physically disconnects it. It's that straightforward. So you still charge, still get full power. It changes the USB spec that it can actually get in terms of rating, but it's pretty straightforward. And it's one of those things where when we set out, we're like, hey, we got to put a cable in the box because that's, we're making cell phones. We could buy one off the shelf for 15 cents and throw it in there, or we could do something where we start from what's the first principles version of, could we put privacy into every product we make, everything we touch? And it's like, all right, well, let's give people really literal physical control over where the data goes. Like, I want it on, I want it off, and I'm in full control of that thing. It costs us a few bucks more. We lost some profit on that, but we're also trying to sell it as a standalone accessory, which has had pretty decent sales for a company of our stature. But really examining every choice we could up front.
In the same sense, then, before we move on to some of the more legislative discussion, the CCPA and how California has used some of its data, really quickly, I wanted to dive in a little bit deeper on how the engineering teams that you managed, the other sort of ways that they were able to implement those privacy by design processes, since we know it's a term that gets abused, it's a practice that means different things in different places. Can you talk a little more about that?
Yeah, I mean, I think some of it comes back to what Jeff alluded to on the previous panel, right? Where there are so back one step, cell phone has by far the most things that anyone does ever, right? Like I spend more time with my phone than I do with my wife and children, right? Than I do with anything else. Like they're nice, but whatever. It's just, it lives with you. It's in my pocket right now. Like there's nothing in your world that's more intimate that you put more contact with. So that's both true physically, but it's also true digitally, your entire footprint. So the number of things that it has to do is all, right? It's all the things. And so the opportunity then from a data analytics standpoint looks unbounded. So if you're coming at it from that, like, what do we monitor? What do we put metrics on? The default answer for anyone in the marketing department, the business department, is going to be all of it, right? So like, let's get those things. That's an incredibly straightforward decision. It doesn't require a lot of thought. So, and at the same time, what an individual consumer is going to be comfortable with and want to have access to is a very personal decision. And we didn't think it was our position to go into that and say, like, we're going to make the value judgment on your behalf. And then when you buy our product, you just signed up for whatever manifesto we've written about what things should or should not be shared and collected, right? And so instead, our intent was to look at the whole stack all the way down to the metal and what's getting programmed in the factory. How can we give people as much control over what they do or not, right? That same example of the USB cable with the switch that turns it on and off is a very literal version of, can I give somebody that agency and that clear responsibility? Now that's easy when it's like talk to a phone through a cable or not. That's a pretty straightforward decision. When it gets down to all the myriad things that a mobile product is able to do, it's almost impossible to get there. So we spent an unreasonable amount of time trying to figure out, like, first and foremost, what hooks do we have into the system? Because some of these stuff is just baked into the chipset, whether it's what Qualcomm's built or MediaTek or what Android's open source platform is doing, right? So there are things we can and cannot do, and everything we could do, we try to figure out, like, what buckets do we put those in, and how do we make those into good UI tools where you go through the list of like what you toggle on and off, and not make it a job where we punted the entire thing to the consumer, right? Because that's the other alternative. So I go, look, I'm not going to make the decision for you, so you do all the work. But that work is Sisyphean. Like, it's impossible to get all the way through that whole stack. So we tried to kind of aggregate and bucketize those things into relatively simple user interface panels, presets for how things can get done, surface them so you're aware of the question, right? Like, here's a dumb example. Like, on our camera app, there's that little incognito button, like, the hat and glasses person, which is desperately cartoony, but it's there. And so the question becomes, like, why do I need an incognito button for a camera app? Well, because your camera takes all kinds of data, right? Like, you got your geolocation, you've got the information about your device itself, and all the other metadata that gets fingerprinted into that thing. Maybe it's feet, I don't know. So we wanted people to just have a single place you could turn that off. What goes underneath that? Sure, you can get under the hood and get into the settings, but like, let's just, every time you're creating data that might get shared somewhere, let's remind you that it has some significance, but not in an obtrusive way, just in a way that's there, just present. Choices available. So we did that for every decision we could, in as much as we kind of had room within that platform.
And I think this was actually a really good example of where the policy space and where the engineering side could interact with each other. So in the policy side of things, all the time the debate is over opt-in, opt-out. Should the default be we can collect whatever you want and you as the individual have to figure out how to turn it all off? Or should it already be minimal collection and then you can opt in if you want to share more? We made even these features, they would be already by default on the device, but an individual could go in and say, like, oh, I really want to know where that picture was taken. Please include the location information on there. You can turn that on for yourself.
So in talking more about the legislation and policy, one of the things I want to jump into before we take on questions here is, since you were the co-author of the California Consumer Privacy Act, and since Joy has such extensive experience in the public sector with how data there is used, I'm curious if you guys can talk a little bit about the history of government regulation over the use of data and the sort of pushback you might get in when you try to implement privacy protective policies, both at the policy level and so that other people can make informed decisions at sort of a company level to inform leadership and people on your team of the value behind making some of these decisions.
All right, Joy, why don't you go?
Yeah. Yeah, I mean, I always, when I think about the regulatory landscape, I like to think of at least two big buckets that I think are helpful for a lot of people engineering in this space in writing policy. And the first is in a very broad swath, I like to think the EU is paranoid about business use of data, and in the US, we're paranoid about government use of data. And I mean, the US was like founded on government paranoia, essentially. And this regulatory, it's generic, but I think it sort of flows through, right? And so in the US, we see much higher regulation of public sector use of data, government use of data, than we see of private sector use. That's why they have an omnibus privacy law in the EU. We will never have a single omnibus law because we will always be more heavily regulated in the public sector. And in the US, this actually, there's a wonderful book by Chris Wiggins. It was published recently, How Data Happened. And it talks about sort of the policy conversation that started to emerge when people were like, wait, what are databases? And you can have like collections of information on individuals over time. And there was a big debate about having a federal privacy law in the US. Well, guess what that turned into? The Federal Privacy Act of 1974, and it only regulated government use of data, no private sector use of data. And of course, this fed and unlocked the advertising economy in a lot of ways. And then in the US, we also have a sector-based approach to regulation. So we have HIPAA, and then we have HIPAA for health data at the federal level. And then, of course, California has to be a little different. So we have CMIA in California. And then, having been CDO of San Francisco, which I like to describe as legislatively active, we'd have our own different versions. And so what this led to is essentially a web forest. I don't know what the right analogy is, but the laws at the federal level, the state, and then the county level, depending on which county you land in, they're highly variable, and they are incredibly complex to navigate. And so that's what the regulatory landscape looks from the public sector side. If I was on your side of the fence, I'd try to avoid that at all possible. And I used to actually advocate for an omnibus privacy law in the US. Now I have no interest in that, which we can talk about if you guys want to. But this is a nightmare to navigate, and the way that we have figured out how to navigate it is all through process-based approaches. So I'll just give two quick stories and then stop talking. So in the public sector, there was this thing called the open data movement. I don't know, anyone hear of this? Anyone? Essentially, this is the proactive publication of machine-readable data, including regulated data, which is a fascinating contradiction. But I was working with the department that manages evictions in San Francisco, and evictions are a perennial hot topic. And they were so nervous about mass publication in machine-readable format of decades of evictions data for a variety of reasons, including landlords could actually use it to deny people, right? Housing. And so what we ended up developing was the Open Data Release Toolkit. And is this I think someone said it in the prior panel, anonymization is dead. We all know this, right? But there are things we could do to make it harder. And so by having these process-based toolkits with some mathematical tricks and hacks in there that we use, we were able to get to this sort of release of data. On the flip side, we have a challenge of actually using highly regulated data. So let's say someone's homeless and they're receiving mental health services, and they're involved in wealth care, and their children are involved in the foster system. All of those are distinct systems regulated differently. So at the state of California, every time one department wanted to share regulated data with another department, guess how long, if they managed to share data, was not a given, guess how long it would take to negotiate on average?
18 months.
18 months. I've seen negotiations take 10 years and finally result in a court order demanding data exchange. So what we did at the state of California is we created an omnibus data sharing agreement, and the adoption of that drove data sharing exchange agreements across departments from on average 18 months to 72 days by having these sort of like very boring process-based tools in place and agreed to upon across the organization.
And I guess I'll go back to the start of CCPA. I'm not going to go into all the details. It's a long sordid tale. But we started working on, CCPA was actually an initiative before it was passed by the legislature in 2018. So we started working on the initiative in 2015, so before GDPR. I came from public sector, federal government, and when I started, I really wasn't a privacy person at all. And the joke was I used to be a spy, and then I became a privacy advocate. But to Joy's point, when I started, I mean, there were still some articles written even in 2015. It was a different world, but it was fascinating to me, just the outrage over the government collection of information, but yet we had these huge companies that were collecting massive amount of very, very sensitive personal information. So I was counsel on the House Intelligence Committee when Edward Snowden revealed the NSA wiretapping program. I can tell you there was actually quite a bit of oversight on the committee, and yet we had outrage when it was revealed what happened and how much information and what was done. And it was highly regulated. Nothing, though, about what was happening with the private collection of information until Cambridge Analytica, thank you, Facebook, that helped us get CCPA. But like fast forward, I mean, the regulation space right now really is a mess. We can go into more detail about that. I actually think we have a pretty good shot of passing the new federal bill. We'll see what happens. I've been wrong more times than I've been right about that. But I think actually the way, if we're serious about changing how data is collected and how it's used, I think actually it's technology that's going to have to change it, and it's going back to what information is collected and how are we using it and what meaningful choices are we giving consumers and how easy do we make it to be that will end up giving people back some control over their data.
Before we move on from this subject, the most popular question on Slack right now is tied to what we just discussed. Joy, why no omnibus privacy law?
Because you private sector lobbyists will pocket full of holes. I think I would like an omnibus privacy act for public sector use of data with standardized and harmonized definitions and allowable exchange and allowable use. Because just it's so breaking the public sector, the variance and regulatory frameworks that we have to navigate. The already risk-averse sector is made more risk-averse when they are confused about what rule prevails and how. So I just learned that after watching what happened to CCPA, how many people have read it? How many people have read GDPR? Yeah. So, and I was like, when I read CCPA, I was like, oh my God, there's like a lot of Swiss cheese holes in here for lots of things. And like, we could never do this in the public sector. So I think in the US, the regulation of private use and public sector use, I unfortunately do think they need to be segmented for a variety of reasons. And then because of the lobbying influence, I think you still need to continue with sector-based in the private sector because I just think you won't get it through otherwise.
So I'm gonna disagree with Joy. I think we do need a federal privacy bill. I think though, to Joy's point, it has to start with enforcement. One of the issues that I had with what eventually got passed by the legislature was enforcement was really weak. In the initiative version of CCPA, we had a private right of action, and we had enforcement by city attorneys, district attorneys, city prosecutors. There was a lot of people who could come in, and if something was going wrong, just at least legislate or legally try to stop it. But it's been really interesting being on the company side of things. So our company, OSOM, we weren't selling direct to consumer. We ended up building a phone for Solana, which is a cryptocurrency, the Solana Saga. So that they were selling to consumers, and they had to build out a privacy program. So I was helping them. They didn't have anybody in-house to do this. And so we started interviewing a lot of these companies that shall go nameless, who were providing different solutions, because they weren't big enough to have their own solution in-house to the problem. It was amazing how much money people are making with really bad products. So I think that, but then the problem is when you have all these smaller companies that still need privacy programs and the solution out there isn't great, you're not doing anything to protect people's privacy. And yet it's the biggest companies that are able to have everything in-house, and it doesn't matter how many different laws that we have in different states, they're able to comply. And it's not necessarily changing people's behavior. So I do hope that if there is a federal privacy law, that it will at least even the playing field. I feel like I'm giving the talking points for the opposition.
So I think we have another question here. I think it was something you said, Mary, or perhaps Joy. Anonymization is dead. There's some, that seems to be a contentious opinion. Some parties have definitely done it poorly, but that doesn't make it dead, and we've seen it done it well today. Is this a widespread point of view in the government and regulatory circles you run in?
I don't know. No, it's weird. All these the privacy conversations I have in government circles are like all about the legal stuff, which is so complex. It's less about the engineering aspects and how to design it. I think until the tools are so readily and easily usable, and there's some assurance built in that is known and visible, you're just, let's put this in context, at least in the public sector space. Like, there's how many jurisdictions in California? Like 30,000? And they're all individually in charge of trying to figure out how to like manage this stuff with their data. And frankly, the market hasn't given them user-friendly tools. Or let's talk about the joke that is coerced consent, right? Like, the tooling that's available for us to do this is either too technical or requires too many resources. And so people are just doing more basic things like banding and things like that. And so I just don't, until you folks, sounds like I'm in the right room, people who actually know what they're doing, until you make, and it can't just be like open source, narrow source, where like there's 5 people working on this and it's great. Like, I want like ecosystems around privacy enhancing technology. And we don't have that, and we're not gonna be able to do that in the public sector, at least the way we fund and think about the public sector in the US. I have hopes for other jurisdictions around the world. But I think it's just, in practice, it's impossible for us to do not only at scale, but across highly variable levels of competency and technology and experience and everything. And so I just don't think there's enough of a rich market out there to do this well on your own.
This is a very much still an emerging field. This is something that this conference has existed like, I think about 5 years now. And one of the things that is very tricky, as you point out, is that there are 70 bazillion jurisdictions, which I will point out is a really good reason to have a federal privacy law, because it is impossible to go and make something different for every jurisdiction unless you have technical people for every jurisdiction. And if we are, math defines what is possible, right? And software just defines what is practical. And to the extent that we do have a more robust conversation between people who are in all of these fields, we will be able to make regulations that make good societal choices that are within the realm of the possible, which is not always the case with things that we are doing in regulation. And I say this as somebody who reported bugs in CPRA, right? I do read the laws, and I am reasonably technical.
Go ahead.
Hi, I'm Tarek. I am a privacy engineering consultant. And Mary, you said my favorite word, which is enforcement. And since it is PEPR, it would not be spicy without a spicy question. To quote, I think, Molly on the Slack, a fine is just a cost of doing business. So for the folks on the panel, what do you think, there's been a lot of moves in privacy enforcement, algorithmic disgorgement becomes the big one. What are other things that you think that would be effective in really kind of pushing things, particularly in the private sector or public sector?
A private right of action. For the non-lawyers, that means that individuals can sue and there can be class actions.
Yeah, I think we have to look at what happens in the life cycle of a bill and the lobbying that happens and how effective it is, right? Like, I mean, just look at how consent works, right? Like, it's just silly. Why do I go to the same website over and over again and and I'm the person who actually goes through and like, depends, I love the ones that are like reject all, one button, which I feel like suddenly we have, what's that?
There's a law called e-privacy, and if it forces that particular fun type of interactions. The reject all button comes specifically from the CNIL, the French Data Protection Authority. Sorry.
Yeah, and so we see the inadvertent harmonization, but like the level to police and do that everywhere. And so the point at which we're solving that problem when you visit a website is a terrible point, but it was lobbied into it, right? Like, why weren't the browsers told that they need to just have a default, like
Do not track.
Like, why do I have to make that decision with every interaction on every website on every platform I am on? And so the regulatory machinery gets shaved into these so I just think it's going to be very hard to have an efficient regulation in the country on which these companies originated.
But what actually is interesting in the proposed text of the American Privacy Rights Act, which is the latest federal version of proposed privacy legislation that does have bicameral, bipartisan support, which still who knows if it'll happen or not, but it does have a private right of action in it. It also has preemption, which for the non-lawyers means that CCPA will no longer exist, and the Maryland privacy law and Washington state and go down the list, that the federal law will be the law of the US.
So we have another question here on the Slack. Any thoughts on the increasing fragmentation of the privacy regulation space and how we combat divided attention amongst specific requirements? Sort of touches on some of that.
Yeah, I mean, I think we kind of already covered that. We respectfully disagree. I mean, actually, though, HIPAA is a good example of a federal privacy law that sets a floor, not a ceiling. But then to Joy's point, there's a lot.
We should say also, I don't even know that we disagree. Maybe I've grown, I don't want to use the word cynical, but just watching the process, right? And I think it would be really cool if we had an omnibus privacy law. I just think what will happen during the regulatory cycle, after the legislative cycle, and how will it actually manifest, and how effective will it be? And then once it's locked in, and then how close will it get to technical specifications that are archaic in 5 years? I just feel like we've seen this pattern play out so many times.
But which is why you really do need this private right of action, because instead of just having the fine be a cost of doing business, I mean, you don't know what the fines are going to be unless you comply. Or don't comply, I guess then you would find out.
All right. Oh, go right ahead. Sorry.
I I really love hearing about all of the different approaches that you guys have talked about, the design phase and the regulations and sort of how the data has been used and what, and then we're talking a little bit about, the evolution of all the regulations. Having worked with a number of people who've had to respond and react to that, in particular at Google, right? A lot of adaptation to new variations of European data protection law, California, all of the other states, and it's not. I don't think it's efficient, and so anyway, just a little bit of a statement that the regulations seem to be a reaction. Like you got to do something, right? Like people don't know what's being collected, they can't control it. We got to tell them, put notices. Opt out of everything, and it's not really great for the user. So, and my question really is more of a matter of how do we, maybe as a industry or as a society, shift away from using things like regulations as the mechanism to control or enforce or whatever, and it sounds like you've had some experience of trying to build things in that actually give users control, but are we not there yet? Like, how can we get further down that path? People don't seem to understand collection is almost necessary for the operation of products, for providing the utility and giving that. But where do we actually shift away from, all these rules and then put them more back into, products and services, and so it's a little bit more self-evident?
I mean, I think some of the speakers have touched on this, right? Like there's, right now, I think still, even with all this regulation, there's still the mindset that, oh, we should collect whatever's possible because there might be some future use for it. So it's saying, no, like what do we actually need? And so there should be some cost to holding on to that information, which, I mean, I was hoping, I don't think CCPA really changed that, but I was hoping that if there's some danger, maybe like if it can be breached or if it can be used or misused, then it would force companies to only think about what they actually need to collect and collect that information. And then I actually think Google's doing a better job, but it's actually making privacy choices easier to use and making the privacy piece of it the default and not what has to be opted into.
You're also asking companies to be like, yeah, let's not make money without regulation. I mean, as long as surveillance capitalism intersects with the ad economy, like, this is where we're at. I mean, look at the size of this room, and we're in Silicon Valley.
So can you elaborate on that?
Like, if this was a priority for these companies, this conference would be gigantic.
I think the inverse of that, and I want to make sure you guys get some time for questions, but the inverse of that is, can we find and prove out new business models, right? And I think, I've already alluded to our struggle to make that really get a lot of traction. But I think there are business models today where they are fundamentally going to be at odds, and it's about trying to find some gray zone in between where that works. And that will always be impossible because our definitions of what gray is appropriate will be shifting on an individual basis, right? And so I think, our approach from a purely business standpoint was to not play the game whatsoever. Like our revenue model was hardware sales, which, is a pretty low multiplier for venture, but gets us into a place where we don't have to collect a single bit of data because it doesn't serve our bottom line in any respect, and actually does us a better job for us to say we're hands off of that because it improves our credibility for our customer. I would hope that there are new business models where what you're paying for is the privacy, is the control. And there are examples of companies doing this in this room, but they're in the minority and we shouldn't kid ourselves. So until we see some good business cases where we can point to that and be like, look, this is another way to make money, I think it's going to be a long-term struggle.
And I know there's other questions, but regulation has to be a piece of it, but I actually think the way to change the solution is through technology.
Go ahead.
I had a question regarding the private right of action. Mm-hmm. So this means that it puts the onus on the individual consumers to prove that they've been harmed by some bad companies' privacy practices.
Yep. That's what.
But like that's really hard, right? Like,
Well,
how
okay,
does
so
that- how does this-
so CCPA, not the version you all have read. The initiative version of it gave individual Californians the right to sue a company if any of their rights under CCPA were breached. So you told a company to stop selling or sharing your personal information, and they continued to do that. You, as an individual, could go sue that company. So you didn't. That was the harm. So it gave you standing to then sue. So you didn't have to prove damages. Which is why, actually, sorry, I didn't mean to talk a lot about it, but there is a lot of pressure on the legislature to pass it through the legislature and not in the initiative form of it, because we had this broad private right of action. And in California, the only way to change an initiative is through another initiative. And so if they wanted to repeal it, it would have had to have been at the ballot box.
Go ahead.
Hi, I'm the geoprivacy lead for Google. So first, on behalf of the people who did all the anonymization for the data that we did when there was March,
Thank you.
welcome, but also thank you for taking all that data and doing something good with it. It was really awesome. On the topic of regulation, I think, just to speak for some conversations that I hear from maybe that may or may not have happened around me, sure. I think actually there's more. Can we talk a little bit about the business case for regulation? Because there is a business case to say, look, right now today you're asking me to not do a thing that I don't want to do anyways, which is this surveillance capitalism. If there's a regulation, then I'm not fighting with other large company. They also have to do that, and then it's that's the new game, is who can comply the best. Is essentially now the game, to say it, but I can't do that without the regulation to comply against.
Yeah.
Otherwise, I'm asking just a bunch of capitalists to turn around and say, do it out of the goodness of your heart. Now, I am very good at that. But you don't want to rely on me for that. So can we talk about the business case for setting the rules and how that can be a path forward? And please.
Yeah, I mean, and I think you said Google, right? Yeah, so like, I think you have a lot more incentives than like, are they called Meta now? Right? And so, you know, because they have kind of their closed box ecosystems that they can keep you in. And so it's a different, yeah. I think this would be an interesting conversation. I don't know how to have the conversation. I don't have the right knowledge, experience, anything for that, but I've had versions of this conversation with friends that shall not be named, working at very high policy levels, where it's like, is there a way to break us out of this? And I mean, maybe, I don't know, but we got into this.
I think the case for regulation is you also have a fiduciary duty to your shareholders to make money. And so if you have regulations in place that say, like, you still need to make money, but you can't do it by, let's say, selling sensitive data, then it kind of gives the businesses, it forces them, but it gives them an out when they're having their board meeting.
Or like, let's think about gas and carbon, right? Like, that's a space where, I don't know, for how many decades we've been talking about regulations to change that market. And I think you could argue that as long as there's capital to be extracted, there will be machinery around fighting a regulatory system that harms that until the bitter end, or as long as possible, right? So like, we're still subsidizing, you know, the things we're still subsidizing in this country, right? Even though we're shifting, quote unquote, to green. And so I think if we just pay attention to other stories where there's entrenched players who can make so much money, how do you actually introduce a different regulatory ecology to incent the shifting of the underlying marketplace? And I think it's happening, right, in that analogy, but it's taken decades.
Play them against each other. You go to one set and you say, hey, you're losing in this market, but if there was a regulation, then you can play against it. And then you let their giant capital of just let the lobbyists fight. That's my suggestion, but I don't do much government.
I think that's a good note to go out on there. So thanks for listening to our panel.